Start. Shri Sudhir Kumar Singh contends that by virtue of the provisions of Section 55 of the 1965 Act, whatever benefits are available, the acquisitions under the Land Acquisition Act 1894, the same would automatically be available to all such acquisitions under the 1965 Act. Stop. He submits that since the 2013 Act refers to the provisions of 1894 Act and the acquisitions made thereunder and is a beneficial piece of legislation for farmers, then by adopting the analogy of the latest apex court decisions, the provisions of the 2013 Act should also be read as extending benefits to the acquisitions made under the 1965 Act. Stop. In the event such as interpretation is avoided, the same would result in discrimination and will violate Article 14 of the Constitution of India. Stop. The contention therefore is that Section 24 subsection 2 of the 2013 Act and its implications are also clearly available to acquisitions made under the 1965 Act under Section 28 and Section 32 thereof read with Section 55. Stop. Shri Singh has then invited the attention of the court to the decision in the case of UP Awas Awam Vikas Parishad versus Jainul Islam and another reported in AIR 1998 SC 1028 to urge that in that case also where the matter relating to payment of higher compensation arose, the same was interpreted in favor of the tenure holder so as to include the subsequent amendments that were brought about in the 1894 Act to pay higher compensation. Stop. He therefore submits that discrimination was clearly the issue that was resolved therein, and it was held that the compensation payable for acquisitions under the 1894 Act would be directly applicable with all its subsequent amendments in relation to acquisitions under the 1965 Act. Stop. It is in this matter that the legislation was interpreted to be a beneficial piece of legislation and was therefore extended in order to avoid discrimination. Stop. Such analogy should also be applied in the present context of the applicability of the 2013 Act. Stop. Para. He has then invited attention of the court to the decision of the apex court in the case of Nagpur Improvement Trust versus Nipendra Kumar and others AIR 2002 Supreme Court 349 to contend that here also the apex court had ruled adopting the reasonings of Jainul Islam's case to hold that by virtue of Section 55 of the 1965 Act amendments that were brought about in 1894 Act will also be treated to be incorporated for the purpose of extending benefits of higher compensation. Stop. He submits that such a construction would be leaning in favor of constitutionality of the provisions of 1965 Act, or else as in the present case it would result in repugnancy. Stop. He submits that different principles of compensation cannot be adopted for the purpose of extending such benefits, which issue was also dealt with in the Nagpur Improvement Trust case in para 54 thereof, and he has then relied on the analogy that has been drawn for extending the benefits of the 2013 Act in certain contingencies to the aid of tenure holders. Stop.